7 February.
Lordship, item number 18, hearing matter. May I pray for an adjournment? I couldn't prepare the matter. Yesterday I was not unwell, Lordship.
Is
Hearing matter.
while counsel for the petitioner seeks adjournment of hearing of this writ petition by expressing personal difficulty, preventing her from preparing the matter today, preparing the matter for argument. First up, considering the ground on which the prayer is made, same stands allowed. The hearing of this writ petition stands adjourned for 2 weeks. Yes.
Obliged.
May it please, Your Lordship. Lordship, with the consent of the other side, I beg to mention item 15 of today's daily list. Lordship, my senior has some personal difficulties.
Who is your senior?
Mr. M.K. Chaudhary,
You have informed the other side.
my lord,
Huh?
I have.
Mr. Chaudhary is appearing for whom?
The petitioner, my lord. Secondary Ali Ahmed.
Mr. Chaudhary's name is shown for the respondent.
Yes, my lord, it's shown wrongly. While talking to the respondent, government counsel,
On the prayer of learned counsel for the writ petitioner, hearing of this matter stands adjourned for 2 weeks. List accordingly.
oblige, my lord.
Supplementary list for withdrawal item.
Why you want to withdraw?
Well, the respondent issued to redress our grievance, madam.
Mr. F.A. Laskar, learned counsel for the petitioner submits that the grievance of his client has been redressed during the pendency of the writ petition, and therefore he has instructions to withdraw the writ petition. The prayer is not opposed by Ms.
P. Hazarika.
P. Hazarika, learned counsel appearing on behalf of the respondent number 4. In view of the above, this writ petition stands disposed of on withdrawal. Any interim order?
No interim, my
No
lord.
entry.
Then I also stand disposed of.
With liberty to file, my lord. Oblige.
Daily list for admission item 1.
May please, your lordship. Lord, here in this case, my lord, the petitioner is functioning as a Kaji of Hing and my lord, Laharigarh police station area, and he has challenged the advertisement of appointing a new Kaji of the same area, Annexure 5, my lord. And my lord, in this case, my lord, matter is pending 2017, and we have represented, my lord, the registrar, Honorable the Registrar General Assam, as well as the Commissioner Secretary, my lord. They may be directed.
No, what do you mean by sought to be appointed? Who is sought to be appointed?
My lord, they have made an advertisement to appoint some other person, addition, more person in the same post, my lord. I am working there. I have been appointed in the year 1968. I am working there. And if another Kazi appointed, my lord, partially, my lord, it amounts to negation of my.
But that is not the subject matter of the court. It will be inconvenient for you.
My lord,
If another Qazi is
My lord,
appointed, it will be
appointed.
inconvenient for you.
my lord, that will, my lord, the Kazis are not the salaried persons. They work,
No, no,
they
maybe,
take part of the registration fees, my
Mr.
lord.
Siddharth, you cannot enforce your convenience in a writ petition. You have to enforce your right. What is do you have a right to be the sole Qazi of that area? If you have it, we'll stay it. Otherwise, we'll dismiss the writ petition. That's how the court proceedings function.
My lord, one area should be one Kazi, my lord. If two
Why?
Kazis
Why?
there,
Because
that too without cancelling my.
why? Cancel his appointment.
Lordship, my lord, my learned friend was submitted a wrong submission. Lordship, my lord, the advertisement is given in the Botodua, my lord, newly created, my lord, that MMR, my lord, Lordship. Lordship, I kindly say he was working in the Dhing and my lord, Dhing area. As per my instruction, Lordship, I kindly goes to this instruction.
Botordroba is under Dhing Revenue Circle.
That is the newly created, my lord, the
Dhing, I am
as per
appointed
the, my
for
lord,
the
that
Dhing also.
public
Dhing
Lordship.
area also. I am also for the Dhing area, my lord. Appointment of MMR Kazi at Dhing.
So where is the order of appointment of the petitioner?
My lord, annexure one, my lord, page 13.
But this is also, my lord, that temporary he has been appointed, my lord, in earlier.
I'm working since 1969.
So Mr. Sikdar, you have understood, no? These matters cannot be entertained by the court. You show me a provision of the rule which prohibits, we'll set it aside. Your opinion cannot be enforced in a court of law.
My lord, partially affecting my
Maybe.
earning, my lord. I have
There
to
could be
earn.
more appointments, but what can be done? What can be done? What can be done about it? Is it barred under the law?
No, there cannot be specific bar, but if
that-
one appointed in place of others, then my lord, the earlier man has been denied his livelihood.
Possible, possible, possible.
Hmm.
Possible. You argue on the law points.
My lord,
not-
the matter may
don't
come
make
up
a
another day,
political
my lord.
statement.
I will,
Huh?
my lord, another short date, my lord, will
Alright.
come.
He
Harding
was
Park,
seeking, lordship, my lord, the disposal of this matter.
Mr.
Now,
Sikdar, learned counsel for the petitioner, also heard Mr. J. Handu, learned standing counsel, Revenue Department, Assam. Mr. T. C. Chupia, learned additional senior government advocate, Assam. Appeared for the state. Harding Park, list again on,
Per week, my lord.
yes, 6th of February, 2024 as a fixed time,
oblige, your lord.
as a fixed part and matter.
Lordship, my lord, that instructions,
Instruction, you take it back, take it back. Instruction.
if required, lordship, my lord. I have a second copy.
No, you place it again next day.
Oblige.
Malad, matter regarding malad compensational appointment, malad. The grounds of denial, malad, is malad possible fine, malad. Malad, lordship may kindly see page 27, malad.
Yes.
Malad, the ground of denial is given, malad, at serial number 12, malad.
Yes.
Page 27, my lord. Serial number 12, my lord. Farooq Ali Ahmed. The ground is the applicant passed HS and applied for the post of pump operator and could not consider due to want of vacant post. And as the remaining period of the service of the disease was only 10 months, my lord. That part has been, my lord, set aside by this honorable court, my lord.
And that order has been stayed by the division bench.
My lord. And the other part, my lord.
You know, you are telling only half of the story,
My lord,
which
and the-
suits you.
My lord, and the other part, my lord. My lord, it's also suits me, my lord. The other part, my lord, that they have stated that, my lord, my lord, my father was, my lord, working as a farm proprietor, my lord. And my lord, lordship may kindly come to page 21, my lord.
No, Mr. Goswami,
My lord.
is it a fact that the deceased employee had 10 months service
Yes,
left?
sir.
Then on that ground, you are out
My lord,
unless the judgment
Yes,
the
my lord.
31 is
my lord.
upheld.
My lord, it's
31.
it is state, my lord, as per my information, my lord. So, my lord, lordship, my lord, this may be kept pending, my lord. Only state.
These are complete unnecessary litigations, logging this.
My lord, thing is this, my lord. Otherwise, lordship may kindly see the ground, my lord. My lord, I have take 30 seconds only, my lord. The ground that, my lord, I have applied for the post of pump operator. My lord, I have never applied for any post, my lord. Kindly see my application, my lord.
No, you did not apply for any post,
My-
correct? But if your father expired, is it?
My lord,
And the petitioner's father
My
expired. So if he had less than 10 months service, then unless the notification is set aside,
my lord.
you're out.
And my lord, the other person who has been, my lord, appointed, my lord, his application has spent its force, my lord, because 3 years has been expired, my lord. Passed over, my lord.
So
So he
how,
cannot be appointed, my lord.
so how, even if he's set aside, you cannot be appointed?
My lord, but my lord, I have already also, my lord, challenged his appointment, my lord, on this ground, my lord. Because my lord, his application could not have been appointed, and my lord, we are similarly situated, both are my lord. have been
Goswami,
just passed.
I'm surprised that instead of arguing on sound legal principles, arguments are made on
My lord,
emotional.
my lord, my lord, maybe possible, my lord. My lord, till my lord, this decision for the division bench, my lord, or my lord,
Otherwise, they spend their force, lordship, they, in principle 10 of the
No, we'll
OM
dismiss
lordship.
all this petition.
Lordship, but in the OM,
He will, he will be very sad if it is dismissed today.
my lord.
But
Madam.
it's time for you and councils to realize that these matters are not taking you anywhere. Of course, you can take a chance because somewhere you might get something. But nobody is being appointed in these kind of orders. That is also a reality. You are just making the client run from pillar to post. No appointment order has been given under compassionate ground. Based on any of these orders, consider his case, etc., etc. The committee will go by what is the edict of the circulars, norms, and these orders. It has to be done immediately, otherwise it's gone. Not a matter of right. So your clients are entitled to take a chance, and lawyers will not lose out on an opportunity that we understand. Adjourn for 8 weeks.
Right.
Awaiting the decision of the so-and-so, awaiting the decision of the division bench in the writ appeal, wherein the judgment and order dated 31/2022 or 23.
24.
Huh?
23, Lordship.
23
Last one.
is under
That's right.
challenge. This matter stands adjourned for 8 weeks. List accordingly.
Obliged.
Lordship, Lordship, I'm filing the affidavit today. I have just now, it has been signed, Lordship. I'll be filing during the course of the day.
File it, we'll take it up at 2.
My lord, then my lord, next week, my lord, my senior Bidjar sir, there is some personal problem today itself, my lord. Next week, my lord, any date, my lord.
You are appearing for whom?
For the BTC, Lordship.
Mr. B. Chaudhary and SCPTC submits that he has received instruction and the affidavit will be filed during the course of the day. Mr. F. A. Hassan, learned counsel for the petitioner, seeks posting of this matter in the next week on the ground that his senior has some personal difficulty. In view of the above, that this writ petition be listed again after 10 days by tagging the affidavit, if any, filed by the departmental authority.
Obliged.
I got 4.
Made lordship. Matter pertains to appointment of compassion ground lordship.
Fix for dismissal.
Lordship, I'll try my best to. What happened in this case, lordship? My case ought to have been considered as per the earlier notification, lordship, but my case has been considered as per the 2015 notification. My father died on 21/2/2013, lordship. At that point in time, lordship, the 9 notification was in vogue, lordship.
What is the qualification of the petitioner?
Lordship, he is B, lordship.
So he is, since 11 years, he is waiting for that compassionate appointment job.
Lordship, he is.
Tell him to wait for another 20 years.
Lordship. Oh, my limited point is, lordship, what happened? My father expired in the year 13, lordship. Immediately I applied. And at that point in time, lordship, the 2009 notification was in vogue. However, my case has been considered as per the 2015 notification, lordship. As per lordship, the 2009 notification as page 27, lordship. Lordship may peruse the order dated 7/9/21 passed by this honorable court, Lordship. In this case, Lordship, they were directed to place the vacancy position, Lordship. That has not been done, Lordship.
So this 5% quota is not applicable in your case.
Lordship, applicable, Lordship, as per the 2009 notification, Lordship. Lordship may peruse Annexure 7, page 27, Lordship.
Yes.
Lordship, this is Lordship, 2nd March 2009, Lordship. I am reading the first paragraph, Lordship. State government has adopted a scheme of OM dated such and such, to give appointment on compassionate ground to the widow, son, unmarried daughter, adopted son, adopted unmarried daughter, government rights harness in view of the giving immediate financial assistance to the family of the deceased in class 3 or 4 post, not above the restriction or above LDA, limiting such appointment to 5% of vacancy occurring in a year. This restriction is, however, not apply where one vacancy is to be filled up in a year. Thus, the department can appoint one person on compassionate ground against 5% quota up to 20 vacancy in a year, Lordship. That vacancy which arose within that year, and that has been modified by the 2015 notification. It has been made as 5% cadre strength.
Where is the 2015?
Lordship, 2015 notification, Lordship, at page 32, Lordship.
Which part does it?
Lordship,
modify?
Lordship. Fourteen, Lordship.
Sorry?
Plus 14, Lordship. Plus 14, Lordship. 14A, Lordship. Compassionate appointment can be made up to a maximum of 5% of the total strength of a cadre, Lordship. At page 36, Lordship. 14A. Compassionate appointment can be made up to a maximum of 5% of the total cadre strength of the cadre man in position in a cadre at the time of recruitment in any grade 3, not above the level of junior administrative assistant, directly by grade 4, maximum of 5% of the following method shall be adopted. I am hit by this, Lordship.
Yes, so 5% of the vacancies arising in a year,
Lordship.
subject to the criteria that the total will not exceed 5%. That is the meaning.
That was not there in the 2009 notification, Lordship. That was pursuant to this, Lordship, this honorable court by order dated Lordship 7/9/21 asked the learned counsel for the department to place the vacancy position of that year, Lordship. Lordship may peruse the order dated 7/9/21, Lordship.
So 5% of vacancies arising in which year?
Lordship, my father died on 21/2/13, and immediately I applied 13, Lordship. It was 12/13, Lordship.
So vacancies of 2013 will be relevant.
Lordship, Lordship,
Is it?
Lordship.
Yes, how many vacancies were there in 2013?
I'm sorry, Mullah, that vacancy position is not right with me, Mullah. But even
The order of the court.
correct, Mullah. I somehow missed the order, Mullah. Kindly give me 2-3 days time, Mullah. I'll-
The only thing we are doing is fixing the next date, either the petitioner wants or the.
No, Mullah, for providing that information, Mullah, I don't have that information right now. Otherwise, kindly see, Mullah, the vacancies, even if the vacancy position of 2013 is we take, Malad, the 13 vacancies as on today may not be available, Malad.
No, but if it was wrongly denied, then you have to create superannuary post and appoint him.
But in fact,
Uh,
Lordship, I
the-
kindly
the-
see.
The officials can't say that we have made a mistake, but forget it, he has missed the bus. That can't be the stand in a court of law. If there was a mistake, you have to appoint him by creating a superannuary post.
But his case was in fact considered, Malad. The SLC has rejected the case because the 5% quota doesn't cover him. Because on it at the time of consideration, Malad, the office memorandum was 1/6/2015, and that provides that 5% of the cadre
So
staff.
which will be applicable? The OM on the date of consideration or OM on the date of application?
Malad, as per the Malad, NC Santosh, Malad, the OM on the date of consideration, that would be applicable.
I have
Consideration of the application.
Lordship, my landed friend is
Para-
relying para 99.
Para 19. Malad.
Para 19.
Yes, yes.
This is for compassionate appointment.
Compassion appointment, Lordship.
It provides that applying the law governing compassionate appointment culled out from the above mentioned judgment, our opinion on the point at issue is that the norms prevailing on the date of consideration of the application should be the basis for consideration of claim for compassionate appointment. A dependent of a government employee in the absence of any vested right occurring on the date of the death of the government employee can only demand consideration of his/her application. He is, however, entitled to seek consideration in accordance with the norms as applicable on the day of death of the government employee.
So there is a judgment of this court which takes a-
Lordship, I place the judgment of last day, Lordship, passed by this honorable court, Lordship.
it takes a different view.
Lordship,
This is a
that
Because by
Ahid,
adjusting the consideration, the rights can be created or
Ahid Ahmed Majumdar, Lordship. I place the judgment on last occasion, Lordship.
which page?
No, Lordship, I place the judgment.
So anyway, but the Supreme Court judgment will prevail.
Lordship, I'll be submitting that this NC Santosh case may not be applicable in my case, Lordship.
Why is that?
Lordship, Lordship, may I read para 10 onwards? Lordship,
Paragraph of the judgment.
I'll be reading para 14 onwards, Lordship. While coming to
What
the.
what do you want to show first?
What I want to show is that in NC Santosh case, Lordship, what happened, the petitioner before the court were minor at the time of the death of their father or mother, Lordship. 3 cases were discussed, Lordship. And as per the Karnataka compassionate appointment rule, what happened earlier, it was like that, once the person becomes major, he'll be getting another 1 year to apply for the post. If at the time of death of the government servant, he was minor. And subsequently it was amended and it was made that from the death, he will be getting 1 year time to apply, subject to the condition he attained the age of majority, Lordship. That was the amendment made. And in these cases, Lordship, the application was made 2 to 6 years after the death of the government servant. In that view of the matter, Honorable Apex Court held that. Now, Lordship, what will be the date of consideration? What will be the date of consideration that ought to be decided, Lordship? Because what happened, Lordship,
So when was your application considered?
Lordship, that is the day, because I applied in the year 13, Lordship. And my first DLC, Lordship, was on 1/6/2015, Lordship, where I was recommended. And after that, I approached the Honorable Court for my consideration. Pursuant to the order of this Honorable Court, my case was considered by the SLC, Lordship.
When was that?
19, Lordship. Lordship.
So if this judgment, the observations in paragraph
Lordship,
19,
Lordship.
these are general observations.
Lordship, that is my submission, because that's the reason, Lordship, I want to read, Lordship, para 14, 15, Lordship. Here, Lordship,
You mean to say that the line in para 19 is, however, disentitled to seek consideration in accordance with the norms as applicable on the date of death of the government employee.
Lordship.
You want to add one line, but this will not be applicable in case of major. It will be
Madam,
only
Lo-
applicable.
Lordship, because
That can't be
no,
done.
Lordship, I'll be reading for a minute, Lordship, para 14, 15, and 16. What happened, while coming to this conclusion, Honorable Apex Court considered, another 3, 4 cases, Lordship. In initial case was taken in para 14, Lordship, SBI versus Rajkumar, where it was held, because in para 14, Lordship, or in Rajkumar's case, may I read, Lordship? This court in SBI versus Rajkumar, while reiterating that no aspirant has a vested right to claim compassionate appointment, declared that the norms that are in force when the application is actually considered will be applicable. The employer's right to modify the scheme depending on its policy was recognized in its judgment. Similarly, in MGB Grameen Bank versus such and such, this court reiterated that compassionate appointment has to be considered in accordance with the prevalent scheme, and no aspirant can claim that this case should be considered as per the scheme existing on the date of death of the government employee. However, para 15, however, in Canara Bank versus Mahesh Kumar, in context of major shift in the policy, whereunder instead of compassionate appointment and research in the scheme dated such and such, ex gratia payments was proposed under the such and such. The court adopted a different approach. Noticing the extinguishment of the right to claim appointment, this court held that dying in harness scheme, which was prevalent on the death of the employee, be the basis for consideration. And subsequently in 16, Lordship, a 2-judge bench headed by such and such noticed the Supreme Court's view in SBI Rajkumar and MGB Grameen Bank versus such and such on one side, and the contrary view in Canara Bank in Mahesh Kumar's, and felt the necessity of resolution of the conflicting question on whether the norms applicable on the date of death or on the date of consideration of application should apply. Accordingly, in SBI Shiv Kumar Tiwari, the court referred the matter for consideration by a larger bank so that the conflicting view could be resolved, reconciled. Lordship, this, I have tried to find out this, I have not found this, Lordship, that Shankar Singh, Shiv Shankar Tiwari's case. It was placed before the largest bank for resolution of the issues, Lordship, in respect of consideration, Lordship. The above discussion suggests the view of the taken Canara Bank such and such to be reconciled with the contrary view of the coordinate bench. Therefore, not anything placed on the applicant on Canara Bank Mahesh Kumar, as also opinion of the landed single judge on it cannot be said that appellant's claims should be considered under the unamended provision of the rule revealing on the date of the government employee.
So this Santosh, NC Santosh goes against you.
Lordship, but what I'll be submitting before the Honorable Court, this may not be the ratio of the issue, Lordship, because the matter was placed before the larger bench. And that aspect is there, Lordship. And my second leg of argument will be, Lordship, that what is the date of consideration? That is to be taken into consideration, because when the consideration started, because I have applied in the year 13, is on record, Lordship. And DLC recommended my case. Once the DLC is recommended. my
DLC
case-
doesn't consider. DLC's job is to
recommended, Lordship. So at what point in time, Lordship, the consideration started?
When SLC picks up your
Lordship,
application.
that we consider, because I got my application considered by SLC by filing REIT application, Lordship. So that is
Whatever
there.
it is. You can't say that the date of consideration was prior to 2015. You can't say that.
because I applied in the year 13 line and process was on lordship. Communications were, I have annexed some communications lordship. Communications were there lordship. They are calling for the papers.
Mr. Chakravarti, unless you can show a larger bench decision which
That
dilutes
is,
this,
that is pending lordship. In that case,
what has happened to larger bench?
This is the larger bench, my lord. The three judge bench has decided
No.
this. This is a three judge bench, my lord. Earlier decisions were, my lord, by two judge bench. And my lord,
This is the larger bench decision.
this is by a larger bench, my lord, the three judge bench. And para 19, the consideration before the honorable apex court was whether the particular person has a vested right for consideration of appointment under compulsion of law. Honorable court said that since this is not a vested right and it is as per the policy of the government, so the policy prevailing at the time of consideration will be applicable. That is the ratio in my respectful submission in para 19.
And what do you say, when was his application considered?
Application was considered by DLC on 4/6/2015.
4/6?
4/6/2015. DLC. SLC page 30, page 21, my lord.
lordship, SLC on lordship, 19 lordship.
18. 19/6/2018. Page 21.
Lordship, 22 November 2018 lordship.
Meeting was held on 19/6. The speaking order was passed on 22nd of November 2018. And the office memorandum is of 1/6/2015.
Meeting held on 19/6.
19/6/2018, page 21.
And
The DLC on
speaking order passed on.
speaking order on 22nd of November 2018. The office memorandum is of 1/6/2015, DLC on 4/6/2015.
Anything else you want to argue?
Lordship, this must not, because one thing, lordship, I may disagree with my learned friend that this is the larger bench. This is three judge bench lordship, but Shankar Singh's Tiwari's case is placed before the larger bench. The outcome in this case, lordship, the Shankar Singh issue has not been decided.
Can you show us that,
Lordship, that is pending before the upper apex court.
show us the proof of that?
Lordship, I have gone through I've done my search in the, in
Do
that,
it in another matter. This matter, we can't adjourn it like that.
in that
we
case,
change
I may
the
be allowed,
date then.
lordship, another 2 days time to go through at least if I can find. So, yeah, I have done my research, lordship.
All right, heard so and so for the petitioner, so and so for the state. On the request of Learned Counsel for the petitioner, this matter stands adjourned for 6 weeks. Please take accordingly. Yes. The problem is, unless, give me a relief or adjourn it for 6 weeks. That's the
No, no,
problem.
I'm sorry.
Nobody is ready
No,
for
no,
a
lordship,
hearing.
I placed before the honorable court that, because at the time of
We are
finding of
just
this case,
wasting our time.
at the time of finding of this case, lordship, this honorable court's order was with me, lordship. I filed this case, lordship. After that, lordship, this order came during the period of consideration of my case, because my case was considered in the
There is a decision of the three judges bench. It is obvious that this is the larger bench decision.
lordship.
You are saying it is not, but
No.
you can't say why you are saying it.
No, lordship, what I'm submitting that Shankar Singh's case was placed before the larger bench, lordship. And this,
No, no. In view of the observation by the order passed in Shankar Singh's case, the
lordship,
matter went to a larger bench.
lordship,
But this is the judgment in the larger bench.
here,
It clearly says the two judges bench, two judges. That's why a three judges bench
lordship,
is
in this case,
constituted.
I am praying for 2 days time to go through the same, lordship. Lordship.
Do it whenever you want to.
Item 5 is
These two analogous matter pertains to reservation in promotion to physically disabled persons under the Right to Disabilities Act 2016. Now, the Right to Disabilities Act, Section 34 provides that 4% of the cadre strength of the particular class will be fixed for persons with for quota for persons with disabilities act. Now, the Honorable Apex Court has decided the matter that irrespective of the mode of appointment, whether it's direct recruitment or promotion, the 4% quota has to be is mandatory. Now in the Assam government had issued an office memorandum dated 7/1/2019 under the Right to Disabilities Act, providing that persons with benchmark disabilities will be provided promotion under that quota only, that will be only limited to grade 3 and grade 4 posts. And that is why the present petitioners who were seeking promotion to grade 1 post, they were deprived of promotion under this particular provision of the Right to Disabilities Act. And that was what was put to challenge, that offending provision was put to challenge. And considering the law laid down by the Apex Court in the year 2016 itself, the Honorable Court had, by entry in the very first day, had stayed the offending provision of that office memorandum. And thereafter, even though that provision was stayed, that particular offending clause, after that also there was 3 batches of at least promotions were effected, but the petitioners were not promoted under the disabilities quota. But of course, later on in the 3rd batch, both the petitioners have been promoted not under the disabilities quota, but under in terms of merit.
So now they have been promoted to which post? Grade 1 post?
Yes, grade 1 post.
Grade 1 post in?
Lordship Assistant Engineer, PWD.
So if you succeed in your attempt, then they will get an accelerated seniority.
Yes, Lordship. That
We'll
is,
hear it in due course. We'll admit the writ petition.
Lordship, may I just submit?
Yes.
By order dated 10/4/2023, the Honorable Court had directed the respondents to file an affidavit regarding the regarding this manner in which they have filled up the this quota, this particular PWD quota, and whether there is any backlog of in the particular quota. If there is any backlog, how they proposes to fill up that. They had filed an affidavit stating that the quota is totally filled up. And in response to that affidavit, we have filed an reply stating that we have enclosed the relevant records showing that none of the posts are promotional posts are yet to be filled up.
All right.
If-
So what I'm saying is this is not a matter to be decided in admission stage. You'll have to admit the writ petition. And we'll post it for hearing.
Lordship, yes.
Every matter can't be decided in admission.
In fact, my lord, in my respectful submission, my lord, there is nothing in the writ petition to be decided as on today. If lordship kindly goes to the,
That itself is to be decided.
no, in the prayer in the writ petition, they have challenged one office member.
No, the fact that there is nothing in the writ petition to be decided, is it not a something to be decided by the court?
But that can be decided by lordship in 1 minute, my lord. If lordship goes to para 15, my lord, page 15, the office memorandum, they have challenged the office memorandum. Their prayer is to modify the office memorandum dated 17/1/2019.
You're referring to page?
Lordship, I am referring to writ petition 3299 of 2020 and page 15, the prayer portion. The first prayer is to modify the office memorandum dated 17/1/2019 so as to provide for reservation and promotion in the post of assistant engineer.
That prayer cannot be granted. Yes.
This has already been modified.
They have modified it in the year.
The new office
2020.
memorandum has come,
What is the date of the new office memorandum?
but it is on
26/5/2022,
21.
21. No,
26/5/2021.
22,
Oh, sorry, 21,
20.
22.
22.
21/5/22. Now the promotion is earmarked for all categories, my lord. Earlier it was for only grade 1, grade 3 and 4.
So then,
No, Lordship, that argument is not maintainable. Why? We were on the.
just a minute.
Yes.
So is 21/5/2022 under challenge here?
No, we have not challenged. What has to be taken into consideration? There was a law laid down by the Honorable Apex Court when the writ petitions were filed. The petitioners are claiming their rights under that law laid down by the Honorable Apex Court.
And kindly see the next prayer, my lord. Consider the case of the petitioner for promotion to the post of assistant engineer against 4% quota reserved for persons with disabilities and on causes being shown so and so and so. Now, my lord, they are shifting to another prayer that we should be given the promotion notionally from that day. That is not their prayer here, ma'am.
That is why. we are not-
In one of the IAs, I don't know whether they have praised the IA or not. In one of the IA, they have said that there should be notional fixation of seniority. They have mentioned in one of the IA in this writ petition, but no order has been passed. And Malad, no amendment has been made to the writ petitions prayer made in the writ petition. In the meantime, they have been promoted. What they have said, Malad, what is their case
So
basically?
where is this 21/5/2022? Is it on record?
Malad,
It has been placed by them.
yes, I placed it, Malad. I have a copy, Malad. But what they are now basically says that although
It is-
the persons with benchmark disabilities are available in the cadre strength, but you have not promoted them considering their category of PWD on merit you have done. Well, as the smaller OBC category, the horizontal reservation they are claiming. The OBC candidate, suppose if he is promoted on the basis of merit as a general candidate, even then the OBC quota has to be filled up. In that manner, now they pray that the persons with disability quota is there, that has to be filled up, although some persons on merit are in the cadre. Well, in respect of PWD, Malad, these are horizontal reservations, Malad. The vertical reservation concept of OBC, that the horizontal reservation doesn't come here, Malad. If in the total cadre strength, the numbers persons are available there, whether he is on merit or whether he is on PWD category, Malad, ultimately the numbers are maintained. The reservation, the percentage is maintained. It is filled up, Malad. Nothing, Malad. In fact, there is no pleading as such in this writ petition, and there is no amendment made to the writ petition. So this writ petition, basically on two prayers, in my respectful submission is no further consideration is required in this particular form.
In my humble
No,
submission,
whether their prayer for modification survives or not. Their prayer for consideration as reserve category 4% benchmark disabled category, that has to be either granted or rejected by the court. That is the key controversy. Maybe that prayer may not be maintainable or may be maintainable, but that has to be answered by the court. So to say that there is nothing to be decided may not be correct question. The second prayer is still alive. If it is accepted by the court, then there will be consequences. What the consequences will be is a different matter. If it is not accepted by the court, then the matter is different. This second
fact-
prayer cannot be just brushed aside without a decision.
In fact, in that manner, Malad, their basically challenge is that in the office memorandum, you have kept provision for only grade 3 grade.
No, you are not probably appreciating. This, what you are submitting is your submission. But to say that there is nothing to be decided, that at the moment is just a submission. That is not that can't be the decision.
True, Malad, true.
So whether your submission can be accepted or hers to be accepted, that would require a full length consideration of the matter. So to say that there is nothing, this is an infractious case, that's not correct. Even if the OM is modified, the amended OM does not affect them. They are affected according to them by the OM of 2017 as it stood at that point of time, where you have allowed this, if your argument of horizontal reservation, etc., is to be accepted, then why have you given it to grade 3? After grade 4, why have you allowed it for grade 3?
Malad, in fact, we have filed the affidavit that we have brought on record. Malad, Lordship directed us to bring it on record. What is the post earmark? How many persons are there? In their affidavit in reply, the last affidavit in reply, Malad.
No.
File on-
Mr. Nath, there are two issues here. Now, by the 2022 OM, you have made reservation applicable up to grade 1.
Up to grade 1.
This is what they want.
Yes.
So you have accepted their stand, but only thing is now whether they will get any benefit of the OM with retrospective effect or whether it should be considered only with prospective effect. That's the only question here.
That is my humble submission before your Lordship, that is not their pleaded case. Where is that?
No, what pleaded case? They are seeking seniority in the as 4% disabled benchmark disability.
Malad, Matlab, they have not sought that, that is not their prayer. Matlab.
Anyway, Ms. Borgohain, you may hit a technical roadblock because
Lordship, may I submit? Probably,
No,
the
please
submission
hear,
which
please
is
listen first.
Yes, I'm sorry. Yes.
you may have a technical roadblock. The court may not be able to set the clock back in these facts. So it was a case of some kind of an interim order at that stage. And now the court cannot take the clock back and say that they were promoted in which year? They were promoted in which year? Your clients?
22 and
One-
23.
One in,
22 and
one in,
23.
one in 2020. Matlab.
22
So
and 23.
assuming that your argument is accepted, then also what relief can be granted?
Lordship, as
How
on
can
date,
you be granted seniority with effect from retrospective date when no
Lordship,
exercise was done?
our rights existed when by virtue of the law laid down by the Honorable Apex Court, as on date when the writ petition was filed. And we
What
will
is the law laid down there? Apex court only state the OM.
No, no, that was a different OM itself. And law laid down by the Honorable Apex Court is that irrespective of the mode of recruitment, whether it's promotion or direct recruitment, that 4%, that reservation quota with respect to PWDs has to be.
Correct,
adhered.
correct. It should
Yes.
be. So now what is to be done? How can you be given promotion from a retrospective date? Which date? Who will decide that date?
Lordship, at least our submission is that on the very first day, 1/9/2020 itself, the offending clause of the particular OM issued by the state government has been stayed. And the offending clause was no longer there. After that, at least from the date when the first batch of promotions were effected, from that date, that's at least our promotion has to be.
Not possible. It's complete misconception. There are two things here. Think about it, because next day you will not get a chance to go back again. The OM gives the benefit to 4 and 3, but not to 2 and 1.
Yes.
If the OM is state, that doesn't mean benefit goes to 1 and 2.
Oh.
That doesn't mean that. Absolutely not. If that is your submission, then it has to be tested.
No, no, not
I-
with
So that means if 3 and 4 get stayed, that means nobody gets the benefit of 4% disability quota for promotion. That's the only meaning of that.
Mm.
Now, you have been promoted as a regular on merit,
Yes.
correct?
seniority.
But your case is that they ought to have reserved some vacancies for being filled up exclusively by candidates with disability with a earmark of 4% of the total number of vacancies. They should have done it,
Yes.
but somehow they did not do it. So today, is it possible to revisit that day when you have already got the promotion?
Lordship, I'll be repeating my submission. I am claiming on the basis of the law laid down by the Apex Court.
What is the law laid down by the Apex?
If your Lordship peruses the order 1/9/2020, the first order, everything has been discussed there.
1/9/2022 in which?
Yes,
it
passed in WPC 3317 of 2020. The first writ petition.
Hmm.
Thousand 1613. Jasmine.
We'll hear it, but prima facie, I find some substance in what Mr. Nath has argued. We don't know what is what. This article, section 32 of that act, the purpose is to provide equal opportunity to persons with benchmark disability in public employment, in the sense that they must also get through in public employment if there is a barrier for their entry due to disability. Once the person comes into the system, there is no question of any further barriers. They move on the normal channel. Because they are disabled, that doesn't prevent them from moving ahead. But the mandate of the act is that the persons with disabilities can hold posts which are identified for the purpose.
Yes.
Yes, so there is no question according to me of any further reservation. Question doesn't arise. The departments will have to identify posts which can be held by the persons with disability, whether it's locomotor or any other hearing or visual disability. And these posts are the posts they can handle. They
Yes.
can man.
Yes.
Any other post, if they can handle, then they do not come strictly within the domain of persons with disability. Because if a person can hold a post which if a normal person can hold a post and the disabled person can also hold the same post, then there is no discrimination here, there is no differentiation. So the idea is that because of their disability, they should not be prevented from getting public employment. That is why the act mandates that in a government, this nodal department is social justice. They have to make a list, identify all such posts
Yes.
at different levels. It is grade 3, grade 4 or whatever. And then notify them there is a special employment exchange. They have to be recruited. This whole thing, I don't know on what basis. I have not seen the entire gamut of the law, and no arguments are also advanced. Has been somehow hijacked to mean that it is another facet of reservation for SC, ST or something like that, which it is not.
No.
That
Yes.
is a that is a reservation for social amelioration under Article 16. This is a reservation made under the commitment of the country under the Kyoto Protocol
Yes.
to give equal opportunity to persons with disability. So once they enter the system, that's the end of the matter. There he is right. But then his government was right initially, and with the prodding maybe from the court or wherever. Now they have done something which is a mess.
No, Lordship,
It's going to
after,
create a big trouble for the government.
no, Lordship, what the Honorable Apex Court has held that once the posts are identified, that is the first condition. Posts are identified, then this reservation, this 4% reservation, irrespective of that
No,
has to
it doesn't,
that-
because once you identify the post, these posts cannot be held by anybody else other than persons with disability.
They have reserved, in case of direct recruitment for the same post, they have provided for reservation in case of direct recruitment. So they could not have avoided reservation in case of promotion.
Absolutely wrong. I don't agree with you, but we'll
Lordship, I'll
admit it
submit
and put it.
The other
straight.
decisions also I'll place Lordship. the-
No, these are completely, complete, according to me, misdirection in the matter. Where is the question of giving vertical reservation in
Not
these
vertical,
matters?
Lordship. This is not a vertical reservation.
Say, for example, in the High Court, you are reserving posts of grade 4. You have to identify those grade 4 posts where a person he cannot be given other jobs of another grade 4 post. For example, can you recruit a person in a grade 4 post and ask him to handle the lift? He will not be able to do it. So the earmarking of post is the beginning of the exercise. In Rajiv Gupta, the court noticed that in case of grade A and grade B posts, the mode of recruitment itself is promotion. There is no direct recruitment.
Yes, that there the promotion was there
Correct.
was no
That is
promotion.
the fundamental thing which has
provided.
not been pointed out.
No, Lordship. I'll place all those decisions, and even there are later decisions also. I'll place all those decisions.
I don't know, you are creating a mess, Mr. Nath. And the moment you do it, the courts will push things further.
For the
How are you going to handle it?
No, now, my lord, the 2020 to OM, it has taken care of the situation.
How?
Now, the 4%, the 4% of persons belonging to the disabled category, physically challenged person, that percentage has to be maintained in the particular cadre. Yes, that is not. And now it has to be, the office memorandum provides that it has to be maintained in all the categories.
So that means if,
One to
say, for example, in a cadre, it is 2% only. Then 2% you have to reserve and bring it and fill up those by candidates with reserve category to make it 4%. Is that what your argument is?
But I could not follow, kindly.
No, supposing in a particular organization,
Logic.
only 2% posts are held by persons with disability. So in those situations, what do you do?
The-
Say in PWD grade 4, only 2% posts are held by PWD candidates. 2% are still vacant. Then what will you do?
Out of the total cadre strength, the 4% has to be maintained out of the total cadre strength. But the posts are already earmarked. The assistant engineer post, it is an earmarked post that it can be held by the persons with benchmark disabilities. So any post of that category can be held. And no particular earmark. The vertically post has to be earmarked for that. This is the post only meant for the.
That I tentatively agree with your submission,
Logic.
that this is not a case of horizontal reservation. It cannot be treated and equated with the reservation under Article 16(4)(b) or something like no.
Basically now want to argue that only, my lord. That is what they are arguing now. That you have promoted, but that percentage you have not filled up. That is what they are arguing.
It cannot be done. As the Supreme Court held in this way, that it has to be done horizontally, reservation has to be maintained.
Yes, Lordship.
No, it has to be done horizontally, not vertically. Not vertically.
This is
They are
not
trying.
sorry,
They are
not
trying it
No,
vertically.
we are not claiming it vertical. This is not a vertical.
So and so, and it is submitted at the bar that these writ petitions are ready in regards to service and pleadings and can be taken up for hearing. Having regard to the nature of controversy involved in both these writ petitions, this court is of the opinion that the matter would call for full length hearing. As such, admit the writ petitions. Since the parties are already represented, no further notice is required to be signed in this case. Register to list these writ petitions for final hearing in the third week of April 2024. That's fixed items.
May please, your lordship. My lord, already your lordship, already last occasion, yes, my lord was pleased to hear the matter. In fact, it's based on a very short campus. It relates to, my lord, the training of RCC, my lord, which known as Recorder Certificate Class Course, my lord. In fact, this is a, my lord, training which is required for, my lord, recruitment to the post of Lak Mandal. My lord, in fact, against 22 post, my lord, 22 seat, my lord, for training, an advertisement was issued, my lord, on 28/1/2020. Pursuant thereto, along with others, my lord, the two writ petitioners, my lord, applied. My lord, and their applications were accepted, and they thereafter, my lord, appeared in the written test as well as interview. Now, eventually, my lord, on 24/9/21, a select list was prepared for total, my lord, 39 candidates. Now, what they did, my lord, in fact, by applying the reservation policy, they prepared, my lord, a list who are required to be sent, my lord, for training. And out of 22 seats, my lord, 20 candidates were sent for training. At this stage, my lord, the two petitioners who secured marks more than the candidates who were sent, my lord, approached this court challenging the action, and there, my lord, ouster, my lord, from the training. Now, the honorable court, my lord, while passing an interim order, directed the state respondents, my lord, to allow the petitioner number 2 to participate in the training. So accordingly, my lord, now the writ petition survives only for petitioner number 1.
Why only petitioner number 1 was allowed?
Or 2 was allowed.
Why?
Yes. In fact, what has happened, my lord, from the list, my lord, the select list,
Hmm.
page 47, it appeared, my lord, that the petitioner 2, he secured the highest mark from this list, my lord, that is 88.33. And accordingly, my lord, he was allowed to participate in the training in the vacant seat. Now, so far as petitioner number 2 is concerned, my lord, he secured 84.33. Now, there are 2 candidates, my lord, above him, that is at serial number 9 and, my lord, serial number 10, they secured 88, my lord. But since they were not before your lordships, my lord, they have not come. So, eventually, my lord, I am the person, my lord, who is, my lord, who have secured, my lord, the highest mark, 84.32. And in terms of, my lord, this particular select, my lord, list, at that point of time, one seat was still vacant, my lord. But applying the reservation policy, what they did, candidates securing lesser marks, my lord, they were sent. And from the, my lord, list at page 46, it will also, my lord, appear that the candidate appearing at serial number 15, belonging to unreserved candidate, she was also sent for training, who secured only 73 marks. This is also anomaly, my lord, in the select list. And other candidates who were sent, my lord, they hardly secured 56 marks, 30 marks, my lord.
Where is the advertisement?
Advertisement, your lordship will find, my lord, at page 21, my lord. Annexure 1. Twenty-eight 1/2020, my lord. Ravi.
Yes.
Thereafter, my lord, written test was held on 2012-2020.
All right, so both of them participated, they scored high marks. Persons scoring lesser marks than them were allowed to participate
Yes,
by applying the reservation roster.
my lord.
But obviously roster is not applicable here.
And,
This is
my
a
lord,
wrong exercise.
The division bench has
Lordship,
also
my
held.
lord, that's a earlier instruction. I already been placed in before lordships on an earlier occasion lordships. As per the order dated, my lord, 6/12/2021 lordships.
What is vacancy position? This is a
Vacancy
certificate course.
Lordship, no, lordship. My lord, the vacancy place, my lord, that this course has been started, my lord, on the basis of the vacancy of the, my lord, that particular district lordship.
Hmm.
That is not that, my lord, a general course, my lord, that everybody go and take the training.
Then it
lordship.
should have been mentioned in the advertisement.
My lord, that is not mentioned in the advertisement. That is true, lordship. Even, my lord, that advertisement is given in pursuant to the vacancy, arose in the, my lord, particular, all the district of Assam, lordship.
No, it should have been mentioned which post, how many posts, because you cannot apply reservation in
My lord,
theatre.
this particular, my lord, it was given by the director, my lord, in pursuant to the, my lord, that vacancy. So where, my lord, the vacancy is there, my lord, they in particular district, they have to send us this vacancy position to the director, my lord. After that,
Vacancy of what?
my lord, vacancy of the post of, my lord, that Mundal, Amin and Patwari, lord. But after the training, my lord, they have to,
No, but this is not a recruitment process.
this is not a recruitment
Then-
process,
This is just a certificate they will have.
lordship.
Ultimately,
Even then, my
while
lord,
recruiting, you can apply this criteria, but if that criteria was to be applied in training, or you should have mentioned it.
my lord, that is not mentioned in the, my lord, that advertisement.
My lord, by this order, the Honorable Division Bench by order dated 31/3/22, my lord, in fact has held the reservation policy will not apply, and accordingly, my lord, the writ appeal, my lord, against the interim order, my lord, that was dismissed. So all the persons, my lord, who are below, my lord, the petitioners, my lord, they are sent for training in the garb of, my lord, reservation.
Where is the interim order passed by the?
Yes, my lord, interim order is, my lord, dated is, my lord, 6/12/21, my lord.
It is not an interim order, lordship, that is given, my lord, 1%, my lord, is, the petition number 2 can be accommodated in the, my lord, that, vacant post, lord.
But you have challenged it by filing a writ appeal.
That is. It was silenced, lord.
Yes. Writ appeal, what is the order of the date of the order?
In fact, interim order, my lord,
Yes.
6/12/21, my lord. Go now, go now.
All right, so in the next program, you have to accommodate.
Next, lordship, when the, my lord, that, already, my lord, that, my lord, earlier, my lord, that, training period already been over.
My lord, recently on 17th.
No, my lord,
Batch
that
has
is,
gone. My
that
lord, I
is-
can be accommodated therein, my lord.
no, lordship,
2-3
that
days
cannot
have
be, my
gone.
lord, this is the special bench, it is for, my lord, the BTC area, my lord, the special quota for the BTC and the, my lord, that, not Kasarich. As per the advertise.
Next course,
My
you will be
lordship will
admitted.
make it clear.
Lordship, my lord, it is clear. No, as per the advertisement, lordship, kindly go to the advertisement. My lord, this person, my learned friend has been given, my lord, that last occasion. The 3 sane men. My lord, they are a departmental candidate. Sane men, they are working as the.
I had heard Mr. S.K. Talukdar, Learned Counsel appearing for the writ petition. I also heard Mr. J. Hendrik, Learned SC Revenue Department, Assam, appearing for the respondent numbers 1 and 2. Mr. T.C. Chukia, Learned Additional Senior Government Advocate, Assam, has appeared for respondent numbers 3 and 4. Full stop. On (22/1/2020), the Director of Land Records and Survey, Assam, that is the respondent number 2, herein, had issued an advertisement notice inviting applications from the intended candidates to undergo 6 numerical 6 then bracket SIX 6 months recorders RECORDERS apostrophe S recorders certificate class course training to be held in the Assam Survey and Settlement Training Center, Rajahanagar, RAJHNAGR, Dakhin Gaon, Guwahati -40 for the session 2020-21. In response to the said advertisement notice, the writ petitioner numbers 1 and 2, along with other candidates, had applied for the training program. Thereafter, they had taken part in the selection process, which comprised of a written test
Written and interview, man.
and
Interview, man. Viva voce.
viva voce. Full stop. Upon completion of the selection process, the respondent authorities had published the list of 19 candidates on 24/9 to had published upon completion of the selection process on 24/9/2021. The respondent number 2 had published the list of 19 candidates who had participated in the process, including the 2 writ petitioners. Full stop. As per the select list, the petitioner number 2 herein had secured the highest marks of 88.33, whereas the petitioner number 1 had secured 84.33. Notwithstanding the same, the petitioner numbers 1 and 2 were not allowed to participate in the training program comprising of as many as 22 seats. First up, the petitioners were denied admission in the training course, apparently on the ground that 16 out of the 22 seats were allocated to reserve category candidate. Full stop. Candidates, whereas both the petitioners belong to the general category, bracket unreserved, UN dash reserve category, bracket close. Full stop. Aggrieved thereby, the petitioners have approached this court by filing the instant writ petition. Full stop. Next para. It appears from the record that after taking note of the facts and circumstances of the case, and more particularly the fact that the petitioner number 2 herein had secured the highest mark in the selection process, this court had passed interim order dated 6/12/2021, directing the respondents to permit the petitioner number 2 to participate in the ongoing training course for the RCCC training. Full stop. Accordingly, the petitioner number training. Full stop. The appeal referred by the respondent number 2 against the order dated 6/12/2021, having been dismissed by the division bench by order dated 31/3/2022, passed in writ appeal number 68 of 2022. The petitioner number 2 was allowed to take part in the RCCC training program. However, since no interim order was passed in favor of the petitioner number 1, he could not get admission in the training program for the relevant years. Full stop. By referring to the materials available on record, Mr. Talukdar, learned counsel for the petitioner, submits that this is not a case of filling up any vacancies in the government department, and therefore question of applying the reservation roster would not arise in the eye of law. Full stop. Mr. Talukdar has also relied upon the observations made by the division bench in the order dated 31/3/2022 to submit that for a training purpose, the principles of reservation roster would not be applicable. Therefore, full stop, therefore submits Mr. Talukdar, the petitioner number 1, who had scored very high marks, have been meted out with a completely discriminatory treatment, wherein persons securing much lower marks than the petitioners in the selection process have been allowed to take part in the RCCC training program. Full stop. Mr. Henrik Lanet, SC Revenue Department, Assam, has obtained instruction and submits that due to the operation of the reservation policy, the the petitioners numbers 1 and 2 were not initially allowed to take part in the training program. Full stop. This submits that such reservation policy was required to be applied in case of the candidates undergoing RCCC training program, since eventually the trained candidates would be aspirants for the posts of Lat Mandal in various revenue circles, which posts would have to be filled up by following the reservation policy. Stop. Similar is the argument submission of Mr. Chutia, learned counsel appearing for respondent numbers 3 and 4. Stop. That's right. So we'll hold that reservation is not. Correct.
If a selection is not on the basis of reservation policy, then suppose one category is all selected, get got certificate, then how they will reservation in the point of appointment? Very difficult. There should be selected for a subject code through reservation. Otherwise, unreserved category they have got all the.
Then you mention it in the advertisement.
That is not there, this is wrong only. Otherwise.
I have considered the submissions made by learned counsel for both the sides, and have also gone through the materials available on record. At the very outset, it deserves to be noted herein that the advertisement dated
22-1.
22/1/2020 was issued inviting applications from intending candidates only for undergoing RCCC training program and not for filling up any vacant post. Full stop. There is also no mention of any reservation policy being applicable for selecting the successful candidates in the advertisement notice dated 22/1/2020. Therefore, it is apparent that the by subsequently applying the reservation policy, the authorities have tinkered with the inter se merit of the candidates, which has resulted into denial of opportunity to participate in the training program for a number of general category candidates, including the petitioner's hearing. Full stop. While examining the said aspect of the matter, the division bench of this court had made the following observations in order dated 31/3/2022. Quote koriba. The aforesaid observation of the division bench has remained unaltered till today. Even otherwise, since the exercise initiated in terms of advertisement dated 22/1/2020 was not for the purpose of filling up any government post, the question of applying the reservation roster in the opinion of this court would not have arisen. More so since the candidates, more so since there is no guarantee of employment in respect of any of the candidates who had undertaken, who had undergone the RCC training course. Full stop. It is no doubt correct that the RCCC trained candidates would ultimately be the aspirants for appointment as Lat Mandals, in which event the government may have to fill up these vacancies by following the reservation roster. To that extent, it may be justified for the state to ensure participation of sufficient number of candidates belonging to the reserved categories at the initial stage of conducting the training programs itself. However, even if that is to be done, The said aspect of the matter would have to be clearly spelled out in the advertisement notice, and the same must be in consonance with law. However, no such exercise has been undertaken by the respondents. On the contrary, by ex post facto application of the reservation policy, dehors any indication of number of posts oblique vacancies, the respondents have clearly denied opportunity to meritorious candidates, thus violating their fundamental rights guaranteed under Article 14 and 16 of the Constitution of India. For the reasons stated above, this court is of the opinion that this writ petition must succeed and is hereby allowed. At this stage, Mr. Hendrick submits that the petitioner can be accommodated in the training. Petitioner number submits that since the petitioner number 2 has already completed his RCCC training program, the only and it is only the petitioner number 1 herein who can be granted relief in this writ petition. Mr. Talukdar has also fairly agreed to the same proposition. In view of the above, this writ petition stands disposed of with the direction upon the respondent numbers 1 and 2 to permit the petitioner number 1, namely Sri Dipankar Majumdar, to participate in the next RCCC training program to be conducted by the respondent number 2 without insisting on any further eligibility criteria from him. Yes.
Deeply obliged.
Problem is, you're looking. Oh, number 6. No, no, I did not. It was computer.
Nếu tôi này thì nó có thể nó của này thì bây giờ người ta thì nghe
Jadi na, alat itu bukan rekod.
আমার সিস্টেম লাগছে
Kemana kan? Mana deh, not record not found দেখা আছে কিছুমান।
Chief, my senior is the next in court number 12. That matter will take time. Kindly pass over the matter for a day.
Pass over for the day.
Yeah, for a day, not.
Not make it, my lord, after 1st February, my lord.
Mr. K. Sharma and counsel is present for the petitioner on the request of Ms.
M. Deca,
M. Dekal and counsel appearing for the transport department as
oh Lordship, income tax.
income tax department. This matter stands adjourned for 2 weeks. Mr. R.M. Das, Learned Standing Counsel, Water Resources Department, ASTC. And Mr. R.B. Goswami, Learned Counsel, for one is present. ASTC is response number? R.B. Goswami, one, and also 2, 3 and 4 are present and do not have any objection if the prayer is allowed. In view of the above, let this matter be listed again after 2 weeks.
Much obliged. Please, your lordship. Lordship, as per the earlier order, lordship, they have filed the affidavit in opposition. Lordship, we need 2 weeks time to file the reply affidavit.
They have filed means who has filed?
Lordship,
Who has filed the affidavit?
as the respondent,
Which respondent?
uh,
You're not aware.
lordship, respondent number 3, 4, and 5, lordship.
Yes, sir. We have filed affidavit, my lord. Wrongly, my lord, we have filed same on the same basis of instruction two affidavit. Any affidavit is maybe, my lord, taken up.
Miss, your name, please?
Lordship, N. Dekaraja, lordship. N. Dekaraja.
Miss N. Dekarajal and counsel appearing for the writ petition as 6. Appraised for how much time?
Lordship, 2 weeks time.
2 weeks time.
Reply, no?
To obtain instruction and file rejoinder affidavit in response to the counter affidavit filed by the respondent. Mr. Chichi to and additional senior government at Assam is present
Yes, sir.
and does not have any
2 weeks.
objection at the prayer. Could I record your name?
Yes.
Sir, Y.S. Mannan. Let the matter be listed after the rejoinder is brought on. record.
What's it?
Rejoinder affidavit is
May I please, your lordship? Lordship, as well, kindly peruse the last order, my lord, 24/11/2023, lordship's order, my lord.
Yes.
We have not received any affidavit, my lord.
All right, so you argue?
Lordship, before he starts, Lordship, only yesterday, Lordship, I have, after much persuasion, Lordship, I have received the document with regard to the case. Lordship, here, Lordship, only the issue is that his case was again considered for in the next DPC in 2023. His recommendation has been again kept in seal cover due to the pending prosecution sanction given against him. And that outcome is yet to be known, Lordship.
Just 1 minute. What is the matter here? What is the issue?
My lord, what happened, my lord? I have been selected, I have been by the DPC to get the next higher post to assistant engineer, my lord. Kindly peruse the page 25, my lord. Page 25, my lord.
Page 25.
Page 25, my lord. My name is at serial number 4, my lord. In the top, my lord. The board was also apprised the following status of departmental proceeding against the officers taken under the zone of consideration. My name is on serial number 4. The Ranjit Kumar Mohanto JE agree. Departmental proceeding dispose of with the stoppage of 3 increments by order dated so and so. Prosecution sanction accorded by order dated so and so so and so. High Court case WPC number so and so so and so so and so regarding the stoppage of the 3 annual increments. My lord, now come to the bottom, my lord. Bottom of this same page, my lord. Further, the selection board advised the department to keep the decision of the selection
Selection Board in seal cover till closure of departmental proceeding and till final outcome of the Honorable High Court in respect of the following officers. My name is name at serial number 2, Sri Ranjit Kumar Mohanto, General, to be kept under the seal cover till the final outcome of the High Court case WPC number so and so Sri Ranjit Kumar Mohanto regarding the stoppage of the 3 annual increments. But in the meantime, my lord, what happened, my lord, this case has been closed, my lord. That is lordship will find at page 21, Annexure 3, my lord. I have been not promoted only because of pendency of this writ petition, my lord, not the prosecution sanction, my lord. And that has already been over, my lord. Lordship will find at page 21 and the reliable portion at page 22. We have taken note that this matter of the year of 2013 non-appearance for the petitioner when the matter is called for, the writ petition stand dismissed for non-prosecution. Mr. B. Chaudhary, Learned Counsel, appears for the respondents. My lord, there is no any pending of the writ petition, for which, my lord, my case has not been considered. And regarding the criminal case, my lord, that has been disposed of by acquitting me on 26/7/2018, my lord. This order is available with me, my lord. The certified copy, my lord. The operating portion lordship will find at page 61, my lord. Second last page, my lord. In the instant case, 4 sets of the distinct charges were framed against the accused person regarding the misappropriation of different amounts during the different period. However, from the discussion of the above evidence, we found the prosecution has not been able to prove the misappropriation of any money of any date or during any period by any of the accused persons. As such, the accused persons are entitled for acquittal. Accordingly, the accused persons, namely so and so, Sri Konak Chandra Majumdar, Sri Ranjit Mohanto, and Sri Hemanta Sharma are acquitted from all the charges. They are set up at liberty forthwith. However, the bail bond shall remain in force for next 6 months. So and so, so and so, so and so. My lord, there is no any cases pending against me, my lord. In spite of that, my lord, this was intimated to the department. Therefore, my lord, at the time of in the year of 2021, my lord, the DPC did not take any view in the bottom, my lord, any view against the prosecution, my lord. Only because of the pendency of this writ petition, my lord, that is also over. Already I have been recommended, my lord.
The petitioner is now working as junior engineer.
Junior engineer, my lord.
What is this? There is
Lordship, the review DPC reflects that due to the prosecution sanction, it has been kept in seal cover.
Yeah, but
Since
this-
now he has
Nothing.
produced the order of the acquittal, Lordship may pass appropriate order,
All
Lordship.
right, heard
because-
Mr. D. Burwell, Learned Counsel for the writ petition.
It has to be.
Also heard Mr. B. Chaudhary, Learned Standing Counsel, Agriculture Department, Assam, appearing for the official response.
Lordship, I'm giving the review DPC held on 2023. Perfect. The last paragraph. Lordship.
The writ petitioner hearing is working as a junior engineer and posted in the office of
Gopur, my lord.
you don't know.
No, I know. Lord.
Give me a date, we'll fix it so that you can come prepared.
No, my lord.
So much time cannot be granted, Mr.
Office of the Executive Engineer, Assistant Executive Engineer, Gopur, my lord.
All right, and posted in the office of Assistant Executive Engineer, Agriculture. Gopur. Full stop. In the year 2021, the writ petitioner was eligible for being considered for promotion to the rank of Assistant Agriculture Engineer, and accordingly, his candidature was considered by the Departmental Promotion Committee, bracket DPC, stroke Selection Board, in his meeting held on 21/10/2021, under the chairmanship of Additional Chief Secretary and symbolic and APC. What is APC?
Lordship.
APC, what is the meaning of APC?
Lordship,
Agricultural Production Manager, Commissioner.
APC, from our Agriculture Department. However, the recommendation of the DPC with regard to the writ petitioner hearing had been kept in seal cover as per the reflection made in the minutes of the selection committee meeting held on 21/10/2021. The same was done in view of the prosecution sanction accorded by order dated 21/9/2012 in favor of the for prosecution of the petitioner on charges of graft, and also due to pendency of the writ petition being WPC number 7097/2023 before this court, wherein the penalty of stoppage of 3 annual increments imposed on the petitioner was put under challenge. Mr. P. Chaudhary has also brought to the notice of this court that a review DPC was held on 22/8/2023, wherein the case of the petitioner was once again considered, but the seal cover proceeding was not open, awaiting final outcome of the prosecution sanction order dated 21/9/2012. Full stop. From the above, it is apparent that the reason for not opening the seal cover with regard to the recommendation of the DPC pertaining to the petitioner where dependency of WPC number 7097/2013 and also the prosecution sanction accorded by the competent authority with regard to the petitioner. Full stop. However, from the materials available on record, I find that by order dated 25/7/2023, passed in WPC number 7097/2013, the writ petition was dismissed for non-persecution. As such, WPC number 7097 and there is no application for restoration.
Then
Dismissed for non-persecution, and the petitioner has not filed any application for restoration of the same. As such, WPC number 7097/2013 not pending as on date. Even otherwise, in the absence of any restraint order passed by the court, there was no justifiable ground for the authorities to keep the recommendation for the petitioner made by the DPC under seal cover on such count. Insofar as the prosecution sanction is concerned, Mr. Borua has produced a copy of the judgment and order dated
26/7/18.
26/7/2018 passed by the Court of Special Judge, Assam, Guwahati, in connection with special case number 43/2012, arising out of ACB P S case number 17/2001, registered under section 120(B)/409 IPC, read with section 13 bracket numerical 1 bracket close bracket small c bracket close bracket small d bracket close /13 bracket numerical d of the Prevention of Corruption Act, which goes to show that the writ petitioner herein, along with 4 other accused persons, had been acquitted in respect of the charges framed against them. If that be so, it is apparent that even the prosecution sanction granted by order dated 21/9/2012 to discharge, under the circumstances, there is no justifiable ground for the departmental authorities to keep the recommendation of the DPC under seal cover, thus causing serious prejudice to the interest of the petitioner. Mr. Chaudhary and a departmental counsel has submitted that if a direction is issued by this court, the seal cover proceeding will be opened and thereafter appropriate steps as may be permissible under the law would be taken in the matter. In view of the above, this writ petition stands disposed of by providing that the seal cover proceeding in respect of the petitioner be opened and thereafter the recommendation of the DPC be acted upon with promptitude. Full stop. The exercise will be completed as expeditiously as possible, but not later than 45 days from the date of receipt of a certified copy of this order. With the above observation, the petition stands disposed of.
Oblige, your lordship.
You take back this.
For orders, item 11.
On the, lordship, on the order dated 11th of this month, there was an order to punish the speaking order up to the by the respondent.
But
A
the
copy
speaking
should
order
be
has
given
been
to-
published by the department.
No copy was served to it. As
By
per
the-
the order.
By the-
Give it to him first. A speaking order has been passed.
Yes,
What is the
your
date
lordship.
of the speaking order?
14/11/2023, your lordship.
So then we'll close the contempt case. Right. You take down, heard Mr.
P. Kotogi.
P. Kotoki, learned counsel appearing for the petitioner. Also heard Ms. M. Kalita, learned counsel appearing for the respondent, who has produced a copy of the speaking order dated 14/11/2023 to submit that the order of the court has already been complied with. Mr. Kotoki has also received a copy of the speaking order. In view of the above, speaking order rejects your claim.
Lordship.
In view of the above, by granting liberty to the petitioner to avail appropriate legal remedy against this order dated 14/11/2023, if so advised, this contempt case stands closed.
Obliged, your lordship. Item 12.
May it please your lordship, my lord. My lord, the last order, my lord, 19/1/2024, in the IA, my lord, that departmental council has submitted that the suspension order was not reviewed, my lord. The suspension order, my lord, is dated 22/6/2023 at page 22, my lord. In the IA, my lord.
So what is your instruction, Mr. Man?
Not my instruction, I was supposed to place written instruction, lordship, but it has not been furnished to me. But my instruction, it is already under process. They're waiting approval of the authority, lordship.
Process for what?
That passing of the reason order, lordship.
No, he cannot be continued in, and if they
Lordship,
pass it, then
lordship,
we
lord-
direct them to.
Yes,
appeal.
lordship, the order passed by your lordship, I'm relying upon lordship. Lordship may kindly. Here, your lordship has considered all the relevant judgments, lordship.
That is correct, but this
Yes,
was passed
just
within
another,
30 days.
another one more paragraph in the Ajay Kumar Chaudhary letter. One paragraph only, Lordship. Just 3-4 lines, Lordship. Page 303. 303, Lord. Paragraph 21. Paragraph 1, Lord, 21, Lordship. Just 4 line, Lordship, I am reading. We therefore direct that the currency of a suspension order should not extend beyond 3 months if within this period the memorandum of search sheet is not served on the delinquent officer employee. This is one part, Lords. Second part, if the memorandum of search sheet is served, a reasoned order must be passed for the extension of the suspension. So far as the second part is concerned, Lordship, no time frame is there. And that is what why I am submitting that, Lordship, at paragraph 22. So far as the facts of the present case are concerned, the appellant has now been served with a search sheet, and therefore this direction may not be relevant to him any longer. In this case, Lordship, search sheet has already been issued. So that is my humble submission, Lordship. I leave it to your Lordship. I'm just praying for 15 days time. Within that period, that reasoned order will be passed, Lordship.
No, the point here is that,
Division bench order, Lordship.
yes,
Lordship, so far as division bench order is concerned, the basic issue was whether in case of a suspension under 6(2) deemed suspension, Ajay Kumar Chaudhary judgment is applicable or not. That was the issue in the judgment, Lordship, and court held the judgment passed in the Rekibuddin Ahmed is a correct judgment. So in case of 6(2) also Ajay Kumar Chaudhary is applicable. So that was the issue in that judgment, Lordship.
correct.
Your
So if
Lordship.
Ajay Kumar Chaudhary is applicable, then the review under within 90 days is mandatory.
No, so far
So
as
what they,
if
just
no
just
search
for
sheet
this-
has been, Lordship.
if you continue the suspension without serving charge sheet beyond 90 days, then you have to pass a reasoned order.
No, yes, Lord. If no search sheet has been issued within a period of 13 days, then review of the
Not 30 days,
suspension.
90 days.
90 days, 3 months, Lordship. Then review is necessary. If search sheet has already been issued, in that case, only compulsion is to pass a reasoned order. No
But
time
that
frame
has
is
to be
there.
passed within 90 days.
That is not there. That is what I am trying to impose your law. Paragraph 21, Lordship. Once again, we'll read that, Lordship.
Hmm.
First part, 30 days, 3 months. Second part, no time frame. If the memorandum of search sheet is served, in this case served, Lordship, a reasoned order must be passed for the extension of the suspension. No time frame is there, Lordship. And that is the reason, Lordship,
So
why
then, what is the meaning of the first part then? If the second part is.
in the
without-
first part, no search sheet was issued.
No, so you are saying that suspension order has to be reviewed within 90 days.
If no search sheet has been issued.
But if a charge sheet is
If
submitted
the search
after
sheet has been issued,
160 days also, then also it is okay. But the point is beyond 90 days, the order goes. It's not there.
Yes.
no,
The
if
moment
the.
90 days is
Yes,
crossed,
Lordship.
what you do thereafter is a different matter. The first part says, if it is not reviewed within 90 days, then the order is bad. So you cannot say that I'll do it after 160 days and submit charge sheet, give a reasoned order. How
No,
can
th-
that
This
be?
is my understanding on the Lordship. In the
Wrong
second part,
understanding.
in the second part, Lordship, search sheet has been issued, no time frame has been fixed. No search sheet issued, in that case, you have to review the suspension within a period of 3 months. If search sheet has been
When
issued,
was the order of suspension issued here?
My lord, here the suspension on the 20.
Mr. Das, please take your
Ah,
place.
sorry.
Yes.
uh,
When was it issued?
22/6, 2023, Lordship.
So we are in January 2024.
Yes, Lordship.
Have you served any charge sheet?
Yes, Lordship.
Where is it?
In the petition
When was
itself,
it served?
search sheet was on 9/10/2023.
Okay, charge sheet was served.
Yes, Lordship. That
and,
is why
But there was no review.
the process of passing the reason order. If search sheet is filed, Lordship, in my humble understanding, review is not necessary. Only necessary is the passing of a speaking order, reason order. That process is on, Lordship. Only the approval is pending. Otherwise, file is already before the authority.
Is it correct, Mr. Das?
No,
Charge sheet
my lord,
was,
that charge sheet itself was issued, my lord, beyond 3 months, first of all, my lord. Now, my lord, so far the Ajit Sonowal judgment is that, my lord. There, my lord, lordship has in the division bench stated in para 16,
there are two difficulties you have.
my lord.
The quicker you come to the point, the better it is for you and the court. You did not come to the court on expiry of 90 days. You came to the court after the charge sheet was served. Is that correct?
Yes, my lord.
Yes. Now you want to say that, all right, charge sheet has been submitted, but before the charge sheet was submitted, 90 days has passed. So now turn the clock back and declare that this gap between 90 days completion and charge sheet, that gap was not permissible. So interfere with the order of suspension. That is your case?
Moreover, my lord, till that, my lord, there is no review.
Huh?
Till that, there is no review or extension of the suspension order, my lord. There is only one order, suspension.
No, that is
20
what he's saying.
Yes, my lord.
Because charge sheet has been submitted, where is the question of review?
And because of the fact, my lord, this is the judgment, my lord, kindly lordship was also one part of this judgment, my lord. Para 16, that itself provides, my lord, clarifies that in all suspension matter, where charge sheet, my lord, para 16,
That's correct, that's correct. But
that
you have
the
come
review
after
should
the
take.
charge sheet has been submitted.
yes.
You cannot argue that.
Fine.
Your argument has to be that what happens after the charge sheet is submitted. You did not come to the court before charge sheet was submitted.
My
You
lord,
cannot even argue that. I will not even consider that argument.
my lord, our argument is primarily basically on Ajay Kumar Chaudhary, that para 21,
That will not be applicable.
second line.
That is not applicable.
Second point, my lord. If the memorandum charge is served, a reason order must be passed for extension of the suspension.
Otherwise,
Otherwise, my lord, there is no suspension in my humble
where
service.
is that law?
That, my lord, in the course of, all the cases are different, my lord. Lordship, as to my lord, I have to address on this point, my lord. And now, so for our understanding is that, my lord, where team suspension, one person is arrested on, and this
Mr.
is a
Das,
case
you
of
see,
team suspension.
The reason sometimes I make a conscious effort to spruce up things
My lord.
is that otherwise I've seen sometimes the council go on arguing in areas which have got no
My
relevance.
lord, yes.
For your case, deemed suspension 90 days is irrelevant. We will not even consider that argument. Only thing that is relevant for you is after the charge sheet is submitted,
My lord.
can you claim as a matter of right that there is no scope for review of suspension or pass a reasoned order subsequently? If that is so, either show me a judgment or argue on the law point, as simple as
My
that.
lord, here, my lord, after that submission of that service of memorandum charge, my lord, that was placed under challenge before this honorable court. This honorable court.
In
has
which
been-
case, in which case?
This particular case, my lord. This memorandum charge, my lord, has been put under challenge in the main case, my lord, and I have given the order in page 28. That memorandum has been stayed on the ground. That honorable Supreme Court decision, my lord, 2014 SSC, whereby it is stated that at least for the same charge of allegation as in the FIR and in the department inquiry, if it is absolutely the same one, then at least the department should wait for at least 1 year to see what is the progress of the criminal case. On that count, my lord, this has been pleased to be stayed. Sir. So pursuant thereto, my lord, we made an application. Our application is page 34, my lord. Representation before the authority, my lord. Placing entire facts and events that in the meantime, the honorable court has been also be pleased to be stayed. So since that effort, there is no review of the suspension order. There is no extension of the order also. In such circumstances, we prayed for revocation of the suspension order and for allowing us to continue, my lord. So our representation, this is pending, my lord. 30/10/2023.
Where is your representation?
Page 34, my lord, and the IE.
Page 34 in the IA.
34.
Where is- Page 34 in the IA.
IE, my lord, yes.
The page number doesn't match.
My lord, IE, 3702, my lord. Annexure 8, lordship.
All right, so I have the IA in front. So reason order has not been passed.
My lord.
Let them dispose of his representation in a time-bound manner within 2
Ma-
weeks.
Lordship, it is already under process. Lordship will grant me some time, Lordship. In the meantime, that will be
So we'll dispose of the IA with that.
Lordship.
Yes.
Uh, Take down, heard Mr. B.K. Das, my counsel for the applicant. Also heard Mr. T. Nayak, Leonard, standing counsel,
Finance Department.
Finance Department, Assam, appearing on behalf of the OP numbers. OP numbers 1, 2, and 3. This 1, 2, 3, and 4. Ms. M. Kalita, Leonard, SC, PhD Division, Assam is present on behalf of OP number. The applicant read petitioner hearing was placed under suspension by the order dated 22/6/2023. First up, during the currency of the period of suspension, departmental proceeding was initiated against him and memorandum of charge was served upon the petitioner
Page 26, my lord.
on 9/10/2023. Full stop. Since then, the applicant, petitioner, and it will be applicant, has remained in suspension. Now, since then, however, the applicant has remained in suspension. The basic argument of the applicant is that in view of the decision of the Supreme Court of India in the case of Ajay Kumar Chaudhary versus Union of India and others, quoted in 2015 (7 SS 291), as well as the division bench judgment of this court rendered in the case of, where is it? Ajit Kumar Sanwal.
Read appeal number, my lord, 114.
State of Assam and others versus Ajit Kumar Sanwal and others. Third bracket, writ appeal 114/2022. It was incumbent upon the authorities to review the order of suspension within the period of 90 days from the date of issuance of the same. And if there was any decision to extend the period of suspension of the applicant, the same ought to have been preceded by a reasoned order. First up, Mr. Das has further argued that his client has submitted a representation dated
30/11, my lord.
30/11/2023 before the secretary, bracket annexure numerical 8 to the IA number 3702 of 2023, bracket close, before the secretary to the government of Assam, finance department, dispute, with a prayer to allow him to join in service by revoking the suspension order dated 22/6/2023. But the same has not been considered till today. Stop. Mr. P. Nayak, Lanet, SC Finance Department, on the other hand, submits that the order of suspension of the submits that the process of reviewing the order of suspension of the applicant is under progress, and within 2 weeks from today, a final decision will be taken in the matter. So If that be so, this court is of the opinion that this is a fit case where the respondents should be directed to consider the representation dated 30/11/2023 submitted by the petitioner before taking an applicant for taking a final decision on the question of revocation of the order of suspension. As such, and as agreed to by learned counsel for both the sides, this IS stands disposed of by providing that the respondents, the OP numbers 1 to 5 shall consider the representation dated 30/11/2023 submitted by the applicant and pass a reasoned order therein within 2 weeks from the date of receipt of a certified copy of this order. Whatever be the outcome of the process, the same be communicated in writing within the aforesaid time frame. With the above observation, I stands disposed of.
Obvious.
Let us see what order they pass. then
Yes,
we'll see.
my
But
lordship.
you will have some hurdle to meet here, Mr.
My-
Particularly, you have come late after the charge sheet.
That's good.
That's going to be decisive.
Obliged.
Well, in the writ petition, that interim order may be continued. In the writ
The
petition,
read petition so and so, so and so, so
you may
and so.
file
and
affidavit.
Just again after 4 weeks, interim order passed earlier to continue.
Obliged.
Till the next date. Lord. Earlier was also till the next date. Lord. Obliged, Lord.
Make please, Lordship. Lordship, this petition is filed against the order of the
Order of the
Order of dismissal from service, Lordship.
yes, Lordship. Dismissal of
Removal
service.
from service, Lordship.
Removal from service. Lordship, he was a cook in Sima Sasastra Bal. Lordship, he was granted outpass, but he could not return to his camp on time. Lordship, and after he was brought back, he was kept in preventive custody at quarter guard, and it was further alleged that that while at quarter guard, the petitioner broke the iron net of the prison cell and tried to break the lock by stone. After that, Lordship, charges were framed, and Lordship, the charges is at page 18, Lordship.
Yes, what is the ground on which you're challenging the order of removal from service?
Lordship, disproportionate punishment and his past misconducts were considered while passing the final order, Lordship, in the appeal, Lordship. That two grounds are there, Lordship.
Why it is disproportionate?
Lordship, the charges were.
Your client tried to break open the prison and break the lock.
Yes, Lordship, but the charges were framed under section 22C of SSB Act.
Where is
Yes.
the charge sheet?
Charges
We have the records, Mr. Lordship.
Case number 18. That the order, that is the order, Lordship,
Page number 18
18.
of the writ petition.
Yes, Lordship.
He has annexed the order of dismissal where it is good. Charging.
31/3/2017 is the order of dismissal.
Yes,
Yes, Lord.
Dismissal or removal?
Removal, I am sorry.
remove.
What is he doing now?
Lordship, that I don't know. Lordship, charge number 1 was framed under section 22C of SSB Act. If Lordship comes.
Yes, charge number.
Charge number 1, Lordship.
Hmm.
The accused so and so of 46 Battalion SSB Malbazar is with the offense of striking or threatening superior officer under section 22C of SSB Act 2007. If Lordship sees the Act, section 22, may I read it, Lordship?
Hmm.
Section 22. Any person subject to this Act who commit any of the following offences.
You have the list of books. No.
No, Lordship. I have a copy, Lordship. Section 22. Section 22, Lordship. Any person subject to this Act who commits any of the following offences, namely, uses criminal force to or assault his superior officer or uses threatening language or to such officer or uses insubordinate language to such officer, shall on conviction by force court. Number 1, if such officer is at the time in the execution of his office or if the offense is committed on active duty, be liable to suffer imprisonment for a term which may extend to 14 years or such less punishment as in this act mentioned. And number 2, in other cases, be liable to suffer imprisonment for a term which may extend to 10 years or such less punishment as is in this act mentioned. So, Lordship, I will come under section 22(2).
Hmm.
Then, Lordship, the second charge was framed under section 24C and D.
Hmm.
Lordship, section 24, any person subject to this act who commits any of the following offences, namely, Lordship may skip A and B. Number C, resist an escort whose duty it is to apprehend him or to have him in charge, or breaks out of barracks, camps, or quarters, or Lordship skip E and F, acting on his behalf or when referred upon refuses to assist the execution of, sorry, Lordship, shall on conviction by a force court be liable to suffer imprisonment for a term which may extend in the case of the offences specified in clause D or E to 2 years, and in the case of the offences specified in other clauses to 10 years, or in either case such less punishment as in this act mentioned. And so, and
That is the criminality of the transaction, but he has not been prosecuted under the criminal or the criminal part of it.
yes, Lordship, but charges were framed under this act, this section, Lordship.
Correct. So you say that instead of removal, he should be put behind the bars for 10 years. That's what you're saying.
No, Lordship, not that, but the order should be reconsidered, Lordship.
But why? On what ground?
on these grounds and lordship, his
He has not
past,
denied it, he has admitted
yes, lordship.
then.
And lordship, his past service was also considered, lordship, while in the appellate stage,
It
lordship.
cannot be done.
No, lordship.
Why, any decision?
Yes, lordship. Lordship, paragraph 34,
Detail.
2010.
Yes.
The courts below and the statutory authorities fail to appreciate that if the disciplinary authority wants to consider the past conduct of the employee in imposing a punishment, the delinquent is entitled to notice thereof, and generally the charge sheet should contain such an article, or at least he should be informed of the same at the stage of the so-called notice before imposing the punishment.
And why do you say his past conduct was considered? From where?
Lordship, if lordship comes to page number 25. That is the order of the appellate authority, lordship. Last paragraph, lordship, of page number 25. And whereas the undersigned have taken a lenient view on the matter, examined the conduct sheet and past service records of X number so and so, CT Cook, Vishwajit Mahato, which was below. Then the past services, past record, and the punishments given are mentioned, lordship, in the order.
Lordship, in fact, on a decision of 2017, the Honorable Supreme Court, I'll just read out the paragraph, Lordship. We are in agreement with the findings and conclusions of the disciplinary authority as confirmed by the revisional authority on charge number 1. Indiscipline on the part of an armed force has to be viewed seriously. It is clear that the respondent had intentionally disobeyed the orders of his superiors and deserted the force. This was a case of desertion. Charge number 3, that the respondent had become habitual in committing indiscipline and disorderliness. The reference was made to 2 major penalties of deduction of pay and 1 minor penalty of reduction of 7 days' salary earlier. The disciplinary authority found that the respondent did not improve in spite of being punished earlier. The High Court agreed with the contention of the respondent and held that a fresh inquiry cannot be initiated into a misconduct which a delinquent has already suffered a penalty. The High Court found that any penalty imposed on the charge number 3 would amount to a double jeopardy. We disagree with the findings of the High Court, as we are of the view that the respondent was not being tried again of previous misconduct, as the respondent did not improve in spite of being punished earlier and had become habitual in indiscipline and disorderliness. The disciplinary authority rightly found charge number 3 as proved. The previous, those were taken in.
No, that's not the point here. The point
He
is,
has to be put on notice.
while imposing the penalty, he took note of earlier.
That lordship, of course, that was not.
It is not that during
Yes,
the departmental proceeding, this was brought in.
this has to be put up, lordship. I do agree.
What is the way out?
Considerable time has also passed, lordship. That is
The order of this order is vitiated.
on that ground, yes, lordship.
Tell us, Mr. Chaudhary, otherwise the court will go as per the established norms. But you also have to tell us what is your client doing since 2017? What is he doing since then?
That I don't know, Lord.
Without knowing that, it will be difficult to hold a relief. Could be doing anything.
But he is not in service now, not,
But
they
what
have
is
not
he
joined
doing?
yet.
What is he doing?
I can take the instruction.
He's from Assam.
Yes, sir.
You obtain instruction, you also.
Yes, if
seek
it can be.
judgment. Talk to your
Yes,
officials.
Yes, yes.
Your officials, because these are matters which goes into the root of the whole thing, no? The entire penalty process is vitiated. If that is set aside, he has to be reinstated.
That again has some
You have to pass a
consequences.
fresh order.
I will have an instruction on.
Mr. C. Sharma, and counsel for the petitioner also, Mr. The DSGA hearing for correspondence. They're hearing the party that some this matter is being adjourned till 15 2020 was to enable the council for both the sides to obtain updated instruction on the query made by the list accordingly.
May I please your lordship? Lordship, pursuant to your lordship's order dated 1/12/2023.
Yes.
Of to trace out both the facts and law, lordship, it may require some time during the course of hearings. That leave I am taking. That this is the second round of litigation, my lord. Earlier writ petition was disposed of, but still that non-speaking order. Lordship may
1 minute. Petitioner was an employee of a bank.
yes, lordship. As L2 manager, lordship. Both some statement is also required to be go through and the records also. Lordship may come to page 59, annexure 1.
And what is the order under challenge here?
That order is at page 98, annexure 22. Then again, the second, after High Court's direction also, which amounts to contempt, the High Court's order is just page 95, annexure 21. Honorable High Court earlier round.
No, this is dismissal from service.
No, reduction in rank.
Reduction.
From manager to assistant manager again. Major penalty.
And now he is serving as assistant.
No, he has retired. Lordship has observed it on last hearing, 112. Retired in June 2018. Lordship. Lordship may kindly come to page 59, annexure 1. His promotion order.
No, promotion will come later, but on what ground you are challenging the order?
Oh, entire facts is to be go through, but it is again a arbitrary non-speaking order. No reasoning.
Where is the order?
Page 98, Lordship, annexure 22. For a moment. Then I will enter into the facts. Facts and law, I have prepared the case laws also, compilation. Has been as 13 case laws, 12 from Apex Court, 1 of this court. In place.
No, 98 is the appellate authority. Where is the order of the disciplinary authority?
Disciplinary authority, that order is at disciplinary authority. Yes. Yes, confidential letter dated 5/8/2016, page 79. May I have a look? 79, after that, yes.
Lordship is looking for punishment order. That is
Punishment
at page 88.
Page 88.
He is not even aware.
8/11/2016. In a bit hurry, Lordship. Excuse me. Page 80. Eighty-eight.
Yes, so,
So, my
what is
love, I
wrong
have
with this
reduced
order?
from scale 2 to scale 1 again,
Yes.
with the amount is also reduced with effect from 1/12/2016.
Hmm.
So facts are to be travelled, Lordship.
No, you are pushing the court to facts. I am asking what is wrong with this order. First, you have to tell me.
Yes,
Otherwise,
Lordship.
why should we go into the facts?
Lordship. Entire proceeding was vitiated. That seat manager vigilance is not the competent authority.
Hmm.
So, as well as the findings, the inquiry reports, the findings of the disciplinary proceeding has also not been recorded here. As the
Not
mandate
been-
of law.
Not been, what, sorry? Has not been?
Evidences of the disciplinary proceeding. Inquiry report is, we have also submitted
Mr. Islam, see,
objection.
The
That-
law in this regard is very well settled.
Lordship,
Court has a very limited jurisdiction.
I know it, Lordship,
So what are the grounds on which an order of penalty
Lordship.
imposed by the disciplinary authority can be interfered by the court? Can you please apprise the court on that first? Then we'll go to the-
Lordship, kindly come to page 35 of my writ petition, Lordship, for a moment.
I'm asking you something else. What is the law on this? On what grounds the order under challenge can be interfered by the writ court? Can you please tell us what are the grounds?
Arbitrary, disproportionate, not beyond evidence.
So according to you, this order is bad for what count?
Several grounds are there, Lordship. For that
Mention
only
one or two.
facts,
Mention one or two.
that double jeopardy is also there.
Double jeopardy.
Yes.
That's in criminal trial.
No, again, as well as violation of principles of national justice also. That I will argue. at length.
Unless you give the gist, you will not get a chance to argue. I'll send the matter to some other court. I am asking you again and again. You have to first tell me in a nutshell what is your case. You want to say that forget it, let me argue for
Lordship.
3 days.
Uh,
And I'll tell you what is the case.
Lordship,
That will not work out. in-
that the material witness
Hmm.
on whose regarding whose accounts
Hmm.
the complaint was entertained,
Hmm.
getting jealous of my promotion by the bank authority. He has also not been examined. Annexure 4 is very, very vital, Lordship.
So complainant not examined.
No, not examined.
Is it a ground to vitiate the proceeding?
as well as the,
Is it a ground which vitiates the departmental proceeding?
that is one fact I am telling you, Lordship, that facts are not.
I will not go to the facts before you answer the court's query. You will have to answer the queries first, then we'll go to the facts.
That non-speaking order, Lordship, that appellate power of appellate authority that has, in this case, in regards to the regulation, Lordship, that has been also misused.
Islam, if you do not answer and respond to the court's query, it will be very difficult. You are not answering the queries of the court on the larger legal issue. You have to first tell me what are your submissions. You only are saying facts, facts, facts.
Lordship, after being promoted, Lordship, from scale to
What is this case, Mr. Datta? Can you please tell me is 5 times I have asked, he is not
My Lord,
responding.
he has no point at all. That's the reason possibly he is avoiding it. Now, if your lordship look at, he has manipulated the bank's fund. And if your lordship come to that, is a matter which should be, the punishment should be
That's on
enhanced.
facts, but what is the submission of the petitioner? You must have read the brief. What is
My
there?
Lord, I have read it, but then I did not find any point. He want to say that the amount which has been manipulated is an accounting jugglery. My Lord, it's a trickery in the nature of, my Lord, managing the accounting system. And what happened, my Lord, if your lordship see the charge number 2, what he did, my Lord, when he was caught that he has manipulated 5,000 for his own use. Now, he did one thing. Out of that amount, he has deposited in the SBI account 4,000 and odd. Now, he is not supposed to deposit in the SBI account because his loan is due. So, the customer came and paid 6,500, 6,536. Now, what he did not allow to, he told the cashier that don't deposit the entire amount, deposit 1,500 something, and the rest 5,000 he took away from the cashier. That is the case, my lord, and where I want to say, my lord, the Supreme Court time and again has said when there is a misappropriation of the amount, the only punishment is removal or dismissal.
So that's the problem. You see, I don't know whether he is not responding to the court's
My
query.
lord, he can't respond because he doesn't have that.
Then I will not be able to hear this matter. We go to some other court.
Lordship may kindly hear.
Let him read the charge sheet at least.
I am asking you, what are your submissions in this case? You are unable to say.
Lordship, some document is required to be go through. Lordship, this
Not
is
by me. This is for another court. Next matter.
Only submission, if your lordship has heard,
Somewhere else.
that vigilance officer is not competent. He is not saying how. Let him show the, from
He
the,
is not responding to any query of the court. Next matter.
obliged me.
I think so, your lordship, can it be a head to lordship?
Huh?
Head to lordship.
That too. What is this matter about?
Removal from service.
You have the records?
Records, I don't have the records.
Records will be
The
necessary.
admitted fact, lordship, he has in writing, he has admitted the guilt. The admission there on his part.
All right. That
And
too.
he has preferred an appeal and this appeal is pending.
How many more matters? Who is appearing for the petition?
Lordship, Mr. Sharma will appeal.
Then sounds, at two lordship.
This was the review, my lord. Even the considering my point of disposal punishment, now he is 66 years. His wife is, both are quite old, tribal family from Karbi Anglong. And there's some delay also, my lord, because they would not get the letter sent from here in the deep villages. So that aspect only remains in my humble submission, my lord, and I don't think the other side will also oppose it. Page 38, my lord. The review application. And first, my lord, let me read the rule, my lord, regulation 48. After the appeals are dismissed. 48 gives my lord comprehensive power to the authority. I will hand over the, my lord, the booklet. 48. Review. Notwithstanding anything contained in these rules, the board may, on its own motion,
Where is your review application? Where is the review?
page 38. Because this is made to the chairman, my lord, after the appeal was dismissed in 2019. Yes, page 48, 38.
So 66 years petitioner is.
Now,
What remains in this case?
my lord, only some, if the old couple gets, get some pecuniary, my lord, succor
He
relief.
was working as what?
I was working in the grade.
Sorry?
Assistant Administrative Officer.
Assistant.
Administrative Officer.
And he was dismissed from service in 2016.
Yes,
At that time, what was his age?
he was 16, 60, 59, 50, 59,
59.
58, 59.
And the date of retirement of AO in LIC? Age of retirement?
60 years.
60 years.
60 years.
Just tag on the end of the.
And please point out the order of issued by the disciplinary authority.
Order
Order of penalty.
Disciplinary authority order is monitored page 26. In except 4, my lord. And it is in fact from page 33. Annex 4. He completed 31 years of service, my lord, on the date. In the first page, my lord, last paragraph. Now, upon consideration of the said reply, dated 18/5/2016, received from the seated officer, together with the attendant records of the census, I, disciplinary authority, in terms of the regulation of 39 of the LIC of India, established in 1960, proceed to dispose of the contents of the raised by the him. And under this different decisions, initially he joined the service at
What is, Mr. Chaudhary, your appeal to whom?
In the prayer, this basic prayer is for reinstatement of the petitioner. Now, whether
there, no.
this is page number 18, this prayer number 2, this prayer number B, shall not be issued to direct the respondent authorities to reinstate the petition in service with all consequential benefits. And it's a admitted position, he has admitted the guilt.
No, that is, there is no denial. That the amount of 14,894 was lately deposited, not in time.
So you are seeking leave encashment.
Leave in encashment or my lord, let them decide on the question of disposition punishment, if I can get some pension.
No, how will you do it, Mr. Sharma? You are asking for things which are not legally permissible. You have challenged only the departmental proceeding, not the order of penalty.
Departmental proceeding.
The departmental proceeding, on what ground you are challenging?
Focus on it is, I was lately.
No, it's all right. You are, I'm not asking you individually, but then what is the ground? There is nothing. How can he be reinstated? He has attained the age of superannuation. That prayer is infructuous.
Yes, that is infrastructure, but your lordship, I can always mold the relief, my lord, there is.
We can only ask them to consider leave encashment amount, if any, that has to be paid to him. That is the prayer.
If he's entitled otherwise with regard to, if he's otherwise entitled.
Because that has not been forfeited.
That has
No
not been,
forfeiture.
not been forfeited.
No forfeiture of any retirement
Yes, yes,
benefits.
yes. We are not on that, Lordship.
So you will submit an application before the authorities. There is no forfeiture of any retirement
Benefits.
accruing to the petitioner. So if there is, he is aggrieved in that, he will approach and they will consider and do the needful. Mr. Sharma, what else can be done?
Earn leave, the prayer number C, Lordship.
Yes.
Yes, earn. Reinstatement cannot be considered at this time.
My lord, your lordship kindly come to the review application page 41. Then prayer, my lord, sort of prayer to the board. Page 41.
Review or appeal?
It is, after the appeal dismissal review, it will review, but it is not ordered.
Mentioned as review.
That hardly matters.
Page 41.
Yes. In the entire section, permanent pray before your honor to kindly interfere with the penalties, setting aside the same side and allow me to continue service. That is gone till the actual date of superannuation. With any other minor punishment is deemed fit as otherwise, I along with my family will face irreparable loss and damage with adverse consequences. That is there. That prayer can be taken as pray for some sort of relief which can grant. Remand the matter to to this board chairman.
Paragraph 7.
So where is the order of penalty? Mr. Chaudhary?
Yes, Lordship.
Where is the order of penalty?
30 order.
30.
Yes.
Order that a penalty or removal of service of 32, Lordship.
Yes.
Last paragraph. Now therefore, I, the disciplinary authority, ordered that the penalty of removal of service, removal from service, which shall not be a disqualification for future employment, be and is hereby imposed on Sri Mr. Such and such in terms of Regulation 39(1)(f) of the Life Insurance Corporation of India, Staff Regulation 1960.
And the punishment is order rule 39. Punishments prescribed, yeah, is under rule 39.
Part হিসাবে আছে আপনারটা দিবেন veterans
Well, here also, mother, in the major punishment, amongst others, mother, compulsory retirement is also there. Because here,
Where is the charge sheet?
charge sheet, mother, page 26. Just add, sorry, there is focus 22. There is loss of to corporation to the extent of 14,894. All deposits made, my lord, there was deficiency of 14,894. Otherwise, amounts deposited were 36,000. Then, my lord, again 32,000, 30,000, 43,000, 37,000, 7,000. In these 6 transactions, my lord, the deficiency was 14,894, and that too was deposited but late. In one case, my lord, the amount collected was 27/12/2013. Deposit was more than 28 next day, 28/12/2013. In one case, there was delay. But
So these charges have been proved.
Yes.
full means it is admitted by him also. The irregularity, he is awarded that.
So only thing that can be done is, since there is no forfeiture of any of your retirement dues,
Yes,
including leave encashment.
yes.
If you are aggrieved on that count, you approach the authorities by making an application and they will take appropriate action in the matter within 6 weeks from the date of receipt.
I think,
That can be done.
yes.
All right, heard Mr. Atish Sharma, Learned Senior Counsel, assisted by Mr. B. Dole, Learned Counsel appearing for the late petitioner. Also heard Mr. S. P. Chaudhary, Learned Counsel representing the respondents. Mr. Aggrieved by the order dated
23/6/2016, my lord. And the applicant 14/8/2016.
Page 26, Lordship.
23/6/2016, issued by the Executive Director, bracket personnel, bracket close, disciplinary authority of the LICI, removing the petitioner from service. The instant writ petition has been filed. First up, the writ petitioner herein was serving as
Assistant Administrative Officer.
Assistant Administration Officer.
Assistant
AAO.
Administrative Officer
Officer.
and posted at the Nongpo branch
Nongpo branch.
of the LICI when a disciplinary proceeding was initiated against him by means of when a show cause notice dated 31/3/2016. No.
No, the charge sheet, my lord, page 22.
When
Show cause notice on 31/3/2016.
a charge sheet dated 9/6/2015 was served upon him with the following allegations. Page 22, double click. Page 23, double stop. Thereafter, the petitioner had submitted his reply, but not being satisfied with his reply, a departmental proceeding was initiated wherein the charges brought against the petitioners were found to be established. Consequently, inquiry report dated 6/2/2016 was sent. Wherein wide inquiry report dated 6/2/2016, the charges brought against the petitioner was found to be fully established. First up. Based on the inquiry report dated 6/2/2016, a show cause notice dated 31/3/2016 was issued to the petitioner, calling upon him to show cause as to why penalty of removal from service, which shall not be disqualification for future employment, unquote, should not be imposed upon him. First up. Thereafter, the impugned order dated 23/6/2016 was issued, imposing the major penalty of removal from service upon the petitioner. The operative part of the impugned order dated 23/6/2016 is reproduced herein below for ready reference. Page
32.
32, page 32. Double tick to double tick. The petitioner had referred an appeal before the appellate authority against the order dated 23/6/2016 but the appeal was also rejected by the order 23/12/2016. First up, it is the submission of the petitioner's counsel that although the petitioner had referred a review application before the statutory authority, no action has been taken on the said application, as a result of which he has been compelled to approach this court by filing the present writ petition. Mr. Sharma, learned senior counsel for the writ petitioner, has fairly submitted that the facts involved in this case are not in dispute, but the penalty imposed upon the petitioner, viewed in the light of the allegation labeled against him, is disproportionate and therefore calls for a review by the reviewing authority, which exercise has not been carried out in this case. So, Mr. Sharma has, however, admitted that at present his client is aged about 66 years, and therefore the question of reinstatement of the petitioner in service would not arise, regardless of the relief that is granted to him in the present proceeding. Mr. S.P. Sharma, S.P. Chaudhary, learned counsel for the respondents, has invited the attention of this court, the prayer portion of the writ petition, to submit that the retirement age of an employee of the LIC being 60 years, none of the reliefs prayed for can be granted to him at this stage. Hence, Mr. Chaudhary has prayed for dismissal of writ petition. I have considered the submissions made at the bar and have also gone through the materials available at record. Since the writ petition is being pursued on a very limited point of modification of the order of penalty, and considering the stand taken by the respondents, it would be necessary to refer to the relief prayed for by the petitioner in this writ petition,
18, my lord.
which is as follows. Page 18, double tick to page 18. Although the petitioner has prayed for setting aside the departmental proceeding as well as the inquiry report dated 23/6/2016, there is nothing on record to substantiate. No valid ground has been urged by the petitioner in support of such contention. Insofar as the prayer for reinstatement of petitioner is concerned, since he has already surpassed the age of superannuation, hence the question of reinstatement of the petitioner would not arise at this stage. Coming to the third prayer in the writ petition, which is for release of amount due and payable to the petitioner on account of earned leave, etc. It is to be noted herein that by the order of penalty dated 23/6/2016, only the removal from service of the petitioner had been ordered without disqualification for future employment, full stop. There is no order forfeiting the retirement benefits and other service benefits that would be payable to the petitioner due to the long years of services, that is more than 31 years of services rendered by him with the respondent authorities. Full stop. If that be so, the respondents cannot deprive the petitioner of all such service benefits, stroke retirement benefits, including leave encashment benefits, as may be admissible under the rules, regardless of whether the order of penalty is maintained, regardless of whether or not the order of penalty dated so and so 23/6/2016 is maintained by this court. Having regard to the peculiar facts and circumstances of the case, although this court is of the opinion that this is not a case where the order of penalty of removal of from service is shockingly disproportionate to the nature of allegation brought against the petitioner, yet the petitioner, this court is also of the view that the petitioner cannot be deprived of the service benefits which he is otherwise entitled to under the law. Merely because there is an order of removal from service passed against him. Therefore, this writ petition is being disposed of by granting 4 weeks time for the petitioner with effect from today to submit a proper application before the respondent. Respond numbers? No.
No, two below. Two.
Before the respond number? Two.
Yes,
Hearing.
executive director person.
Release directive, praying for release of all such service benefits which he would be entitled to under the law as a former employee of the LICI system. If such application is submitted within 4 weeks by enclosing a certified copy of this order, the same be acted upon as per law, and appropriate steps as may be required under the relevant rules be initiated in respect thereof within a further period of 8 weeks
Disposal.
thereafter. System. Whatever be the outcome of the process, the same be intimated to the petitioner in writing within 8 weeks from the receipt of the application.
But instead of I making the application in 4 weeks, can it be 2 weeks, my lord? I'll make immediately.
You do it tomorrow morning. You are given 4 weeks.
Within
time to
4
do it.
weeks.
You
Within
do it
4
tomorrow
weeks.
morning.
Okay,
Yes.
within 4 weeks.